831-679-lifestyle.com.
Go ahead and state your appearances.
Good afternoon, Your Honor. Eric Pepperman, Teddy Parker, and Breanna Switzler for plaintiffs.
Good afternoon, Your Honor. Gina Mushmack, Mike Esposito, and Richard Ryan, and Eric Freeman on Zoom for real water defendants.
Good afternoon, Your Honor. Jim Cavanaugh, Nate Arrington, and Dan Polsenberg here today for ETT1 LLC DBA Terrible Herbst. HERBST Herbst.
Okay. Oh, want to go through inclinations?
Yes, please. I'll just speak for everybody.
Yeah, that's why. So we have ETT1's objection to the order on the financial records. I'm inclined to rule or deny that. Nevada beverage motion, let me number 10. My note says I think the testimony here would be part of the punitive phase only, perhaps. If that's, say that again.
I'm sorry, motion limiting number 10, correct?
Correct. And I'd be inclined to deny it as the issues go to weight, not admissibility. Well, the beverages motion limiting 12. Inclined to deny, but not permit the depot to be played in opening. So maybe call that grant part. 13. Inclined to deny that one. Deny. 16. Apologize. I'm trying to figure out what my note. I mean, I can read the words, but inclined to grant at least in part. But not exclude credit card statements and not a blanket exclusion of testimony regarding where real water was purchased. I welcome clarification on that one, certainly. Inclined to deny is too broad. Issues would be subject to cross-examination, impeachment, and go to weight. So I'm inclined to deny that. Deny. 19 grant unopposed. 20 deny. Uh, 23. Yes, I didn't write grant or deny for some reason. But here are my notes that indicate I'm probably inclined to deny it, even though I didn't write that down. Relevant, a lack of written recall policy and or compliance with an unwritten policy and claims and plaintiff damages. So just reading that out loud. Likely inclined to deny that one. 24. Grant in part, of course, grant part to exclude amounts of prior verdicts, judgments, settlements, including those mentioned in any newspaper and articles. The denial would be, read that newspaper article or headline or whatever plaintiff suggests, and I agree, it's highly relevant. So you could redact portions of it that jurors may see in terms of an amount or something like that. So that'd be the one caveat, I guess, to that one. Five. Inclined to deny and allow C. Donnelly rebuttal. And my note says page 3 of the joinder, so I must have focused on that somehow. 26. Deny see the opposition. Pretty on point. Issues go to weight, cross-examination, etc. 27. Similar. Deny weight, cross-examination, etc. 28. This is one where there may be a distinction that I may not quite understand or quite follow that I'd like to hear about. Is there any difference on this one between Mr. Herbst and any of the other plaintiffs? So I'd like to hear about that. I don't know if this is moot, given what I already did in the partial summary judgment. I say alternatively, and you all can refresh my memory, as you can probably tell, the amounts kind of getting to me. Alternatively, deny based on real water stipulation agreements in other cases. We certainly welcome a jury instruction that may address some of the issues raised, but at all. Okay. You all want some time to talk?
That's all.
Oh, there's one.
Yes, we
Oh, okay.
Yeah, definitely a few more.
Okay, she tricked me.
Just a couple.
Yeah. 30 exclude 23 and 2024 pests, deny all the reasons in the opposition. Welcome clarification on this. Probably, although not strongly, probably inclined to grant at least in part. My note also says the reply didn't address the opposition's issues and concerns. So probably one that I'd like to hear some argument on. Uh, 33 grant plaintiff's opposition does not address the limited relief sought. 34 So there's a general rule with me in motions in limine. The rulings are always, whether denied, granted, etc., are always subject to potential opening the door to excluded evidence. And I probably haven't said that before, but that's a general part of the order or orders. And it's why I'm mentioning it now is my note on this one says defense open the door to the relevance. I mean, I can't tell you how many times I've heard alcohol in these hearings. So I think the door's pretty wide open to that. 36. Deny. 37 inclined to grant in part to exclude specific causation regarding Mr. Herbst, deny in part the remainder. $38. Deny. 39. You all will have to remind me where I'm at in terms of ruling with Dr. Atchison. If he is still potentially in and his opinions my note doesn't make sense to me. So welcome some arguments on that. 40. Deny. Page 4 of the opposition in particular gives reason to deny it. Now we're at ETT's motion limiting number 1. Deny. ETT motion limiting number 2. Deny. The next one be real water 1. Okay, good. Real water motion limiting number 1 inclined to grant as to the specifics set forth on page 5, lines 8 through 15. Deny remainder. Y'all want to talk now? Okay, let's go out there and come back like at 2:00.
The objection to the request for a financial records.
Okay, okay,
And your honor, we'll go one by one, and when we get to the next one where we are in agreement or we're gonna stand by your decision, we're gonna let you know.
okay.
Okay.
Okay. Okay, so the objection, all right. Yeah, just be aware of type limits. So there you go.
Make it short.
Okay,
Nathan Arrington for ETT1. The first issue, there was no discovery request for financial records. Second, there was no motion to compel. Regardless, the issue was raised before the special master. And our position was, just like the case law is, the only financial information you're entitled to is the date of the trial. You don't get prior years, and because it's the date of the trial, even if financial documents were to be produced, that would be only 1 year, not the financial record of the company back to when it was first started. And so therefore, even if a production is required, it should only be for the time of trial, which is now. That's all I have to say. Do you have any questions?
no questions.
Thank you, sir.
Your Honor, unless you have a change of opinion, I'm not gonna waste my time arguing it.
No change.
Thank you.
Yeah, the briefs were thorough, but I also think the issue's clearly in favor of plaintiffs on this. So defendant ETT1's objection to the special master order for the 4 years financial records is overruled and or denied for the reasons detailed in the plaintiff's response to the objection.
Thank you.
So does that mean 1 year, 2 years?
I don't know how
I'm just trying to find out what my client is supposed to provide.
so I will I mean, you tell me if I'm mistaken, but I believe that the special master said 4 years.
That's quick.
Thank you, Your Honor.
Next up, I have number 10.
My understanding that defendants wanted to argue this one.
Okay.
Afternoon, again, Your Honor, Jim Cavanaugh for ETT1 LLC, DBA Terrible Herbst, HERBST. We joined Nevada Beverages motion limiting number 10 to exclude financial records of non-parties. Just to be very brief, and I'm sure the court wants that. Plaintiffs have to prove the strict prox liability case, as the court's more than well aware, that Mr. Herbst consumed real water, and Mr. Herbst, H-U-R-S-T, Milo Herbst, suffered injuries from that consumption. And with regard to my client, he's got to prove that Terrible Herbst, the convenience store for my client's business, ETT1 LLC, sold real water to Milo Herbst, which he consumed. They must also prove that that water was defective and caused Mr. Herbst, H-U-R-S-T, actual and proximate
So I'm gonna
cause
take a
damage.
hopefully brief moment. I mean, I know the difference between Terrible Herbst and Mr. Herbst. I know hopefully what plaintiff first is required to prove at trial. I mean, you're welcome to spend time saying that every time, but I don't know that it's super productive.
Very, very good, Your Honor. I just want to point out that I've gotten a couple of transcripts and they're using HERBST throughout instead of Mr. Herbst's name. And it's the transcripts.
Well, I know the difference.
I
I
know.
don't, I haven't read the transcripts, but I know. Okay.
So I'm just doing it for the beginning of today's argument. I won't, I apologize for running the court through that. The reason was the
Okay.
transcript that we've received.
Okay.
Plaintiff's expert, Mark Rich, has been deposed. And in prior cases and prior reports, he's introduced the records of multinational, multi-billion-dollar corporations that don't prove anything with regard to the defendants in this case. And there's just no evidentiary basis for his opinions regarding Terrible Herbst. In deposition in this case, I specifically asked Mr. Rich, had he ever done an evaluation of Terrible Herbst's finances or sales, and he had done none of those things in any of his prior cases, any of his prior reports, nor did he have any report regarding my client in this case. I don't believe that this other information is relevant. Financial records of non-parties with regard to issues pertaining to the issues in this case. I'll reserve for reply. Thank you.
Yeah. Good afternoon, Your Honor. Michael Esposito on behalf of Real Water. We traditionally try and combine the arguments, but for this, there's just a little bit of a nuance that I think we need to touch upon. In this particular case, the most problematic aspect of this, aside from the fact that now the defendants do not have a contravening expert to discuss the scope, is the fact that we've got this presumption that this $10 billion market or whatever Coca-Cola is somehow the predefined market for the industry. And where it becomes a methodology issue is because there is not underlying data to support that. By contrary, the biggest issue here, as I see it, when it comes to meeting the assistance requirement and more broadly to punitive damages, is that we again deposed Mr. Rich in this case. And when we start asking about foundational issues relating to why this data was being used, aside from the fact that he testified last trial that it was because plaintiff's counsel gave it to him, he stated that he started citing these recalls that all of these companies had gone through. And he's arguing that we need to deter these companies and punish these companies because of a history of bad conduct. And Your Honor, we've provided a wealth of law in our moving papers that says that that is absolutely against Nevada law. You cannot base an award of punitive damages to punish conduct of non-parties. This case is not about whether or not Coca-Cola had a recall several years ago or whether Nestle had a recall several years ago. This is about whether or not this is about Real Water and evidence of Real Water's conduct. And I'm quoting from several cases, Your Honor, but a jury may not apportion fault to non-parties. That's Phillip via C.R. Bard. That's a Nevada federal case. Eklund versus Nevada Wholesale Lumber. That's a Nevada Supreme Court case at 93 Nevada 196. Wyeth v. Roat, which I know this court is familiar with, speaks to a similar issue and says that you cannot utilize non-party conduct to inflame the passions of a jury. These are significant issues. And so we know what the motivation is for Mr. Rich to provide this data. And it's arguably to punish these non-parties, billion-dollar corporations for their own historical conduct. And that is absolutely inadmissible. So, Your Honor, aside from everything that co-counsel just discussed, which we obviously join, I think this is really a significant issue. And it can't meet the assistance requirement if it's not probative, and it does not assist the jury in reaching an appropriate decision in this case. If Your Honor has any questions, or I'm happy to direct you to the appropriate parts of the moving papers, but that's
Well,
the
I
premise.
mean, I'm reading on page 8 of the motion has exactly what you just said. So,
And we provide more in the reply as well, Your Honor.
I have no questions.
Thank you.
Thank you.
Your Honor, have you heard anything that would lead you to change your position or any questions you may have?
I don't have any questions, but go ahead and address that. The
I
argument.
would love to, Your Honor. Let me start where defendant started. Mr. Cavanaugh's arguments really don't touch this motion at all. He simply repeated what the burden is for the plaintiff and what he believes the burden to be that we can't meet. That's his conversation. But it has nothing to do with the legal points and authorities in the motion, the oppositional reply, nor the factual content of the motion, opposition or reply. In terms of what Mr. Esposito said, I think he's arguing a different motion, actually, but to the extent it touches on this one, Your Honor, I'd like to address that. As you recall from the Wren case, the numbers put up by Mr. Rich, CPA with over 30 years of experience, was not to punish non-parties. It was to deter misconduct. And Your Honor, fortunate enough for me and I guess Mr. Polsenberg, the Bon Jovi case, which is cited, I tried that case in 2003, I believe. I'm looking back at Polsenberg because he was on the other side of it. He was on my side. He was on the same side on that one.
I think he was saying leave him out of this.
The point being, Your Honor, deterrence is what the Nevada Supreme Court has found to be appropriate. In the Ace Trucking case, it's cited in addition to the Bon Jovi case. NRS 42.005 indicates to make an example of. We've spent our time when it comes to real water dealing with deterrence because they're in bankruptcy. This is not a punishment issue, which is what Mr. Esposito likes to speak of. This is not what it's about. We don't have their financials. And then I would actually say that the argument made by Mr. Cavanaugh in terms of punishment, Your Honor, or in terms of analyzing his company's financials, they've not produced it. It wasn't until the day that the court ordered or denied their objection to this special master's decision. So certainly we'll be getting those records really shortly now, which is great. But you can't come in here and argue that our expert didn't have the financials when they didn't provide them. They objected to them. So, Your Honor, this is a deterrence issue. We've always went in that direction. You remember the testimony from Mr. Rich. And unless the court has something else you want me to address.
No, thank you very much.
Thank you so much, Your Honor.
I'll be really very brief, Your Honor. Mr. Rich was proposed prior to the discovery issue that's arisen here before the court on the objection to financial records being requested prior to the punitive damage phase of the case. I very much believe that if Mr. Mark Rich, plaintiff's expert, had asked or had done an analysis or even asked for the records, he would have gotten them. He's written reports for 3 years. He's never asked, and in cases that Terrible's has been involved in. So how can a so-called punitive damages expert assess appropriate damages based on activities of a company he knows nothing about financially? He admitted so in his deposition. With that, I'll submit, Your Honor.
Thank you. Any additional rebuttal?
No, 2 seconds.
That's okay.
A lot of fun. All right. Just cutting right to the chase, Your Honor. It's troubling to me that we're going to find ourselves in a situation where the court has disallowed any evidence of Real Water's financial condition pursuant to the motion to eliminate yesterday. So now the jury has to have an understanding of something that is in accordance with the NRS, which, obviously mandates that there be some discussion of the financial condition of the company. So there really isn't anything else we can do. And then to pile on, we now know for a fact, despite what opposing counsel is saying, Council Parker's statement that we are not trying to punish these non-parties is demonstrably false. We have the testimony from Mark Rich. It's one of those issues where we now know something that we didn't know in all of these prior trials. So going back to each of the prior cases and saying, well, this information came in, Mark Rich didn't give that deposition testimony until, I guess, maybe 2 months ago now. And so now we know. And so what do we do with that new knowledge? We change our minds. The simple fact is Nevada doesn't allow a party to award punitive damages for out-of-state conduct for the same party, much less non-parties to the lawsuit. So if we're looking at this strictly from a Hallmark perspective, and we're strictly talking about methodology and reliability of the testimony, whether or not it'll assist the fact finder, we know what this testimony is about. And it's not establishing a market for deterrence. It is based inherently upon the prior bad acts of Coca-Cola, Nestle, Granger, etc. So, Your Honor, if that's the foundation that we're going to give the jury, Real Water would obviously object to that because that's inconsistent with Nevada law. Thank you.
Thank you. I'm going to stick with my inclination, deny the motion with the clarification. We're talking about punitive phase testimony only. The issue, all the reasons in the opposition, which are detailed. At the heart of it, the issues here go to weight, not blanket exclusion as the motion seeks to do. So denied for all those reasons.
Thank you.
Thank you.
Well, I think this one always we're seeking clarification. I believe.
Yes, Your Honor, just briefly, this one is Dr. Goldsmith, what they title out of context testimony. I believe your inclination, you said inclined to deny. This is actually the converse of plaintiff's motion in limine. I think it's number 8, where you allowed Dr. Goldsmith's testimony in with under the conditions that you set forth. I believe there's 2 conditions. One of them saying that we had to designate the testimony beforehand and then the questions couldn't be objected to. So I just, like I said, this is the converse of it. So I just wanted to make sure that was explained. Yeah, number 8. So yeah, it's the converse of plaintiff's motion limiting number 8, which you granted.
Sure. So you're okay if I deny this one?
Correct.
Okay, and my caveat was, I guess maybe call it granted part, don't play the depot in opening, I think is what I said.
Yes.
Okay,
Well, Your Honor, you said in the last one, don't play it in opening if there's any objections to the designation without a ruling from the court first. We've served our.
okay, hold on. I can't have multiple people jumping up and down, on the same side at the same time for the same motion. This process is complicated enough. We have a very limited amount of time. So you all got to pick ahead of time. It can't be, hey, I don't like what my colleague said, or I have more to add. That's I can't do it. So you have to pick, who am I listening
Yeah, Your Honor, I apologize, Mr. Switzler will address
and
that.
then the other question is, I mean, this Nevada Beverages motion, I don't know if they want to talk about it or because it's their motion, I wasn't part of your discussions just now. But typically if somebody has an issue with it, usually I'm hearing from the move-in first. But if the move-in said, hey, we want to hear from plaintiffs first, that's fine, but I don't know that that's the case. You
But
tell me.
And Your Honor, Gina Mushmack for the Real Water defendants, and plaintiff did ask for clarification on that, and because of that, I guess that is up the concern about reading in deposition testimony. I'm looking at their number 8, and I guess the concern is since that time, Dr. Goldsmith has said in reports and testimony that the plaintiffs have interpreted my reports and deposition to indicate that hydrazine was a constant contaminant in real water based upon positive findings from the FDA and from Eurofin's laboratories that all real water was adulterated and that all real water caused outbreaks of acute liver failure. This is clearly not the case. The acute liver disease outbreak detected by the Southern Health District of Nevada, FDA and CDC, was from the consumption of real water for 5-gallon drums. So I guess if you are inclined to allow something in opening statements, then this portion of something has to be said about his clarification. Otherwise, it is not a proper designation in the real water defendant's opinion. So to pre-admit his testimony otherwise departs from well-established law and is prejudicial, considering his admissions that his opinions were taken out of context. And that's all. And I think that's been since Gallagher, he has clarified this. So it's new knowledge, once again, that we're presenting to this court today based upon recent testimony and or reports.
I apologize, Your Honor. I guess there was a misunderstanding on what we were stating here.
Well, there may be, so part of what I was trying to say is you all
Yes,
did some stuff outside my presence and I just didn't know,
correct.
if they said, oh, you go first, but go ahead.
Our understanding was that there just needed to be a quick clarification, so I apologize for that.
That's-
Rather, I guess we're arguing it, so just really quick, this motion is moot based on your ruling on plaintiff's motion limiting number 8 to allow Dr. Goldsmith's testimony. And so that was the only clarification that we wanted, and you.
But if in all candor, I have no idea what I said on plaintiff's motion limiting number 8.
No worries, and that's why I was gonna
So,
go into that if you want me to.
Did I do, I guess, but first question would be, did I say these pages and lines are admissible, or did I say something to the effect of, maybe your colleague mentioned something like somebody's got to designate page line?
Yes, so my understanding of your prior ruling, and I guess taking one step back, Dr. Goldsmith was hired by the real water defendants in the first case. He gave deposition testimony and provided 2 reports. After that date, he was then hired by a different defendant distributor to basically recant everything he had previously said. So that's the distinction that we're talking about today. We had requested to pre-admit his prior materials that were when he was hired by the real water defendants. Your clarification, based on my understanding, was saying that we needed to be clear on the stuff that we were talking about was, who he was hired by. So you said you wanted to make sure we were clear rather than just saying defendants hired, real water hired and or being specific. And we had told you that we had already designated page lines to Dr. Goldsmith that we wanted to provide. And you said if there was an objection to the question in the deposition, we weren't allowed to play that deposition testimony unless there was a subsequent order from the court. And so the clarification, I guess, that we needed from this one is, like I said, we think this one is moot based on that prior ruling. And so that's the only reason why we wanted to clarify that.
Okay.
Do you have any other questions that I can
So
explain?
so your take on what I said before is if there was an objection made in the deposition, then you can't play it in opening.
Correct. Otherwise, we could play the previously designated and non-objected to material in opening.
Okay. Thank you. Any rebuttal? Any rebuttal?
No, Your Honor.
Okay, so I'm not going away from what I ruled before, but let me, apologies, because I'm still a little not clear. Have you all met and done page line designation specifically with Dr. Goldsmith?
So we provided our deposition designations as part of our pretrial disclosures, which were about 3 weeks ago, I believe. As of today, and Miss Mushmak. Sorry, I wanted to say her name right, but I probably messed it up. And I actually just discussed today, they will be getting us counter designations here soon so that we can address this. But as of today, standing here before you right now, we do not have any counter designations or any designations from defendant on any depositions.
Anything from defense on that?
Counsel is correct. We'll be providing those two hopefully by Thursday and discussing everything.
The 16th is the due date for those designations. I understood. You're up.
Okay. Yeah, so, okay, so I think I understand better. I had forgotten, obviously, what I did on plaintiffs. Motion limiting number 8. Yeah, so essentially, I still support denial of Nevada beverages, motion limiting number 12. But instead of saying a blanket, don't play the depot in opening, it'd be subject. You can play it subject to my ruling on plaintiff's motion limiting number 8.
Thank you, Your Honor.
Thank you.
Your Honor, we're happy to say that I don't believe there's any argument on the next two.
Oh, shit.
That is correct. That is correct, Your Honor.
So that would be Nevada Beverages, MIL number 13 and 15.
So Nevada beverages, motion limiting number 13 is denied. Nevada beverages, motion limiting number 15 is denied.
That's right.
Okay. So which one am I going? Yeah, so 16, I welcome arguments.
And your Honor, Richard Bryant for defendant Realwater. My understanding is you were either going to give clarification or seeking clarification. And I'd like to maybe get that so we can tailor those arguments.
Okay. What, you want me to give you more input?
Your Honor, I think the question might be, and maybe this speaks to the heart of what we went back and forth on, is the motion of limine is related to the credit card statement.
Okay.
We get into the weeds and the arguments in the motion, the opposition, the reply about essentially what is the foundation for those credit card statements. These credit card statements are essentially unitemized transactions. They're not talking, they don't have any list of like Realwater was purchased on this day. They're simply amounts, dates, who he's transacted with. And so when we get into the weeds, it's essentially arguing, is there a foundation that was somebody with him when he was regularly transacting with Terribles here? And maybe perhaps that would create the foundation to make these relevant and not just something for a jury to guess at what is part of these receipts. It's mentioned that so one of the receipts that was actually produced was just for gas. And so if we've got transactions that are being considered by the jury and they are left to just guess at whether there was any Realwater involved in this transaction or not, it no longer helps the jury. It just leaves them with a question mark of, did this one involve Realwater or not? Was he regularly purchasing through all of these transactions? Was he regularly purchasing Realwater there? And I would actually point to the plaintiff's opposition and what the quotes that they gave. None of the quotes.
Bear with me a second, that's a different binder. Okay, plaintiff's opposition, where are you at?
Page 2, Your Honor.
Okay.
And none of these quotes, going through, you can kind of scan for the word credit card in here. That none of these quotes talk about credit card transactions. They're talking about where was his office located relative to Terrible's? Did they ever see him drinking real water? And in the reply, we kind of dive into they're guessing at a lot of these times. He said that in light, and I'm sorry, I'm on page 3. He said that in light of the article, he's quite agitated and irritated. He got it from the store below his office. That doesn't speak to the credit card transactions. It only speaks to that potentially he was transacting with that Terribles, but he could be paying cash at those times. He could be using different credit cards. He could be bartering with them. We don't know. It's still speculative. And so, Your Honor, I think what we get to in the heart of this motion is that those credit card transactions lack any foundation that is more than speculative on the part of these witnesses that are cited as the basis for admitting those credit cards.
So let me ask you, so what you're seeking to exclude, and I want to make sure I understand exactly what you're seeking to exclude. I think, but correct me if I'm wrong, you're seeking to exclude the credit card, what I would call entries. I'm not sure that's a term of art or not, but the entries that ostensibly show purchases made by Mr. Herbst at Terrible's.
That's correct, Your Honor. I would also note, and it's mentioned that it's not like this is some time ago. So point of sales has changed. We're all used to seeing itemized receipts now. And itemized receipts in terms of the paper receipts may very well likely have been produced. And those would have been in Mr. Herbst's possession. If he didn't want to retain those, that's up to him. However, Terrible's didn't have the technology, didn't have the ability to invest at this point. And so the itemized list, if that were to exist, yeah, perfectly relevant, perfectly admissible. This is using witnesses who can only speculate about how these credit cards transactions could relate to his purchase of real water. And so I don't think that they do anything but open more questions up to the jury.
So when you say witness testimony, so this is where I get a little like, okay, are you seeking to exclude the credit card entries themselves and the type of testimony, or is it one or the other or both?
Well, Your Honor, in all candor, when you tell me you're kind of on the fence about things and seeking clarification, I would say that speculative testimony, that's something that's going to be objected to as it's provided. And certainly, if we get into, were you aware of what form of payment he used when you weren't even there, then that starts to get very speculative. And if we get to a point where that's happening with 7 witnesses in a row, I think Your Honor is going to have low tolerance for that in terms of continuing to ask the same things. So in terms of this motion, this was focused on the credit card transactions, which this testimony is just to elicit, was there a foundation established for those credit card transactions?
Thank you.
Jim Cavanaugh for ETT1 DBA Terrible Herbst. We joined in Nevada Beverages motion limiting number 16 to exclude speculative testimony. The Milo Herbst credit cards purchases were for real water. A bit about those 700 transactions that are redacted. Plaintiffs produced the redacted statements with regard to things that were not Terrible Herbst transactions. They unredacted several transactions that were Terrible Herbst, none of which turned out to be for real water.
I thought he just said you can't tell.
No, well, we can't tell because
not your co-counsel, but the counsel.
Real Water's attorney.
Yeah.
I'm not sure
so let me back up.
Okay.
I thought, and you tell me if he's wrong or if I'm wrong, that's fine, but I thought that he said, given the lack of technology and whatever, and given the lack of actual paper receipts, I thought he said you can't tell that any particular entry in the statement that's with Terribles, I thought he said you can't tell what items those are for. Now you're telling me, I think, that we know none of them are for real water. And I don't know how both those can be true.
Well, allow me to address ETT1 Terrible Herbst technology. Plaintiff produced credit card statements for Mr. Herbst, and they did not redact anything that said Terrible Herbst, or in some cases just said Chevron.
Okay.
And we compared those to Terrible's point of sale transactions histories, which were online and available in the regular course since August of 2019 forward in time. And it could be that Counsel for Real Water was discussing the technology that wasn't available for point of sale transactions prior to that summer. And so we were served with requests for production, requests for admissions, along with plaintiffs' redacted credit card statements. And in fact, what I think you've already heard earlier, we have a motion before the special master to get those credit card statements unredacted to see what he did buy at other places, because Nevada Beverage had produced numerous transaction history of Mr. Herbst at Costco, where he was buying cases of water for some time, and none of them at the same time Costco offered real water. None of them were for the real water product. They were for, house brands of Costco, Fiji, what have you. And I think prior counsel had understood that our technology to get point of sale records only goes back
to 2019.
To 2019 midsummer, basically. And what we wanted to see was the unredacted cards to see where and what water and what things he was buying at other places. Just as an aside, some of that goes to our effort to show that Mr. Herbst wasn't a quote cash guy. I don't know if you've heard that description.
I have heard that term.
Okay.
In these hearings, I've heard also. Yeah, I've heard.
So our argument is, if he was a cash guy, which is allegedly one explanation for why he doesn't have any, receipts for buying real water. Well, why does he have 700 pages of credit card statements? Why is this cash guy, and why are plaintiffs redacting those statements so that we can't see what the cash guy is buying, whether it's gum or just large items? We don't. So that goes to a different issue, Your Honor. But with regard to this motion in limine, Nevada Beverage brought it, and the idea is not to have speculation about what's in those statements. Plaintiffs redacted everything that doesn't say Terribles or Chevron. So if they make an argument that he could have been buying more real water with these statements, that wouldn't be proper. And that flies in the face of the production that plaintiffs have done thus far. And again, we're trying to get the statements unredacted to find out what he was buying with those credit cards, what the cash guy was buying all these years. So I'm not sure if I clouded it more, but we've joined into Nevada Beverage's motion limine 16 to prevent speculative testimony about what might be in these redacted credit card statements. There's no foundation for it. It wouldn't be relevant, admissible evidence of what might be in those credit card statements. We want to see what's on those statements, but plaintiffs aren't allowing us to see that thus far. And there's a motion before the special master to get those unredacted statements. So with that, unless you have questions, Your Honor,
No questions. Thank you.
we're reserved.
All right, Your Honor. I believe defendants' arguments provide the basis to deny this, because it seems like defendants don't even know what they're moving to exclude. And that's exactly part of our point in our opposition is saying, what are they trying to exclude? This is overbroad and vague, and you can't really point down even in the arguments today what they're trying to exclude, whether it's the statements, the testimony, statements about the test, it's a little all over.
Let me
the place.
ask you, do you have any witness who you think can come in and say this entry on this credit card statement that is a Terrible Herbst entry? I can tell as a lay witness or an expert witness that included a real water purchase.
So we actually have Terrible Herbst own request for admissions. And the reason why, Mr. Cavanaugh came in here and kind of muddied the water as far as that goes. But what happened in this case was, and I'm not going to bore this court with all the details of the special master hearing nor get into that because it's not before this court. Plaintiffs didn't only, plaintiffs provided a lot of credit card statements the last four, not only to Terrible Herbst, but to other entities as well that they like to ignore. The fact stands is we took all the ones that were related to Terrible Herbst or what we could ascertain could be related to Terrible Herbst. And we sent those over to Terrible Herbst and said, admit that real water was sold on these days associated with Milo's credit card purchases and statements. And then we attached the statements showing, and then we did it all by date. And in our opposition page 4 and 5 list out all those dates. It starts on page 4, line 27 and 28. It says this includes let me list 1, 2, 3, about 10 different purchases. For those purchases, Terrible Herbst said that they cannot deny that real water was sold on that day because they didn't retain that information. And so the part of these credit card statements are also cooperative in nature. And the reason why we put all the statements of the other people is these credit card statements show that Milo Herbst was frequenting Terrible Herbst. The witnesses say he was frequenting Terrible Herbst. And so this is all cooperative evidence of each other. They can't deny that real water was sold on these days to them because they didn't retain that information as well. So when defendants themselves can't even deny that real water was sold to them, how are they trying to preclude us when we have corroborating evidence of, Milo Herbst, and we've got Mr. Kloby saying that he, was a frequent purchaser at Terrible Herbst. He made several purchases at Terrible Herbst. We have the credit card statement saying he was purchasing at Terrible Herbst. There's a couple other ones that we cite too saying, he was getting the water from his office below, which was a Terrible Herbst, all these things. And so that's why we're saying that it was these credit card statements are corroborating evidence of the testimony of him and of his family and friends who testified that it was his pattern of practice. So especially when Terribles cannot deny that real water was sold, we can't be prevented from setting forth all this corroborating evidence regarding the same. Like I said, defendants are all over the place in their arguments, so it's hard to argue between whether it's the credit card statements or the testimony, and that's why we argue that this is vague and ambiguous and shouldn't be dealt or granted here in this regard. It's an overbroad motion. They had a burden in demonstrating that this is completely inadmissible. That's, the burden that they have in a motion to exclude, and they haven't met that. They can't even explain to this court exactly the reasons. And so for our opposition, we say that this is corroborating, demonstrates habits, is expressly shows, and cannot be denied by Terrible Herbst themselves that they sold real waters on those dates and times, or that Mr. Herbst purchased them at those dates and times. For those reasons, we would say it should be denied.
Thank you. Any rebuttals?
Yes, sure. Jake Cavanaugh for ETT1 DBA Terrible Herbst. I also wanted to correct one statement by co-defendant regarding the store below Mr. Herbst upstairs apartment. I think the court's aware Terrible Herbst leased that property for 11-year period up until 2011, and thereafter Milo Herbst Company Gamstar, turned it into a convenience store called Spring Valley Market there on Flamingo. And Nevada Beverage distributed real water to Mr. Milo Herbst's store, Spring Valley Market, thereafter from 2011, or at some point in time after, long after Terrible Herbst had leased that store. I just want to clarify that. So the reference to a store below the apartment, Terribles did not run that store since 2011. The court asked a very straightforward question. Do you have any witnesses with regard to the purchases? And I think counsel was mistaken. Eventually did not answer that question for a while, but ultimately made some statements that the court will see in evidence is simply not true. The 11 witnesses plaintiffs have identified with knowledge as to whether Terrible Herbst sold Milo Herbst real water, all testified they did not have any knowledge of his purchase of real water from Terribles. All 11 of them, under oath. They were also asked if they had any knowledge about his purchases, and all of them said they did not have any direct. They were not a witness to him buying any product from Terribles. And that included the plaintiffs. I asked the plaintiffs, both of them, if they had any records or if they did any shopping for their father. And they did not have any of his records for Terrible's purchases, and they did not know of any purchases. Now, those are sworn testimony. The court's gonna see all that, as well as the jury will. So this idea that counsel's mistakenly informing the court that there's witnesses to purchases or witnesses to any transaction or documents is not true. It's not accurate. I also want to clarify this all over the place, and we can't deny or admit. So there were roughly 10 requests for admissions, requests for production. And some of them were in Lake Havasu, some of them were in Henderson, a couple were in Boulder City, some of them were in Las Vegas, alleged locations of Terribles. We looked at the records for the stores that Terribles owned during the time period that these credit card statements encompassed. Several of them, either Terribles didn't own that facility or they purchased the facility, that location, after the credit card statement in issue. Of the 10 locations that we investigated, we gave them the responses to what there was a record, a point of sale record. So the only reason we were unable to say we can't admit or deny were for stores, A, we didn't own at the time that credit card statement applied to, or B, we had purchased that location after the credit card state. They gave us credit card statements that span from roughly 2016 till 2024 when Mr. Herbst passed away. And so we tracked down the best we could based on point of sale records, which only had been in existence as a routine part of the system since I believe it was August of 2019, as I informed the court. So whenever we said we don't have ability to admit or deny if Milo Herbst purchased real water at any of those locations, it was simply because A, we didn't own that store at that location at that time, or B, we had acquired it after the credit card statement in issue. So to recap, Your Honor, there are no witnesses for the purchase of real water by Mr. Herbst, and there are again, we're asking for them to produce credit card statements. We're not all over the place. This has been asked for some time. And those are the facts. And those are what the deposition testimony is. And that's what our responses to interrogatories, our responses, requests for production and requests for admissions inform plaintiff. Nobody's holding anything back. You can't admit what you don't know. You can't deny what you don't know. We don't know what another store sold or didn't sell to Mr. Herbst when we didn't own the store at that time. So I hope that clarifies. If you have any questions, Your Honor, sorry for taking so much time.
Any additional rebuttal? No? Okay. Yeah, this may be one where I'm just not, I'm going to deny it without prejudice. You know, trial briefs are also welcome. There might be some key issues that I see that I'm not sure have been fleshed out yet in front of me. It's not my job to advocate. So I'm going to deny it without prejudice. You know, you're welcome to file trial briefs on different issues. This may or may not be one of them. But it's fair to point out, I need to be specific in excluding exactly what, and the arguments weren't super helpful on that. So, denied without prejudice.
Thank you, Your Honor.
Thank you. What's next? Okay, 17, trying to deny, but, welcome, Artie.
Thank you, Your Honor. Richard Bryant for defendant Realwater. Your Honor, essentially what this motion limine is about is to preclude plaintiffs from essentially parading in front of the court, in front of the jury, witness after witness after witness saying, I didn't see him drinking a whole lot. We have evidence through the notes that his doctors wrote about his drinking habits, where he said he was drinking daily. If you were to subpoena 10 of my friends, you might get very different results in terms of how often I drink, how often I don't drink. Essentially, what plaintiffs are trying to do here is they're trying to prove a negative through volume of testimony. Let's have all these witnesses come in and say what their impression is of Mr. Herbst's drinking habits. And we all know we have different friends, we have different times where we might engage in different behaviors. That's human nature. And so in order to try to show that he either drank real water on a habitual basis or didn't drink alcohol on a habitual basis, what plaintiffs appear to be doing through having seven witnesses that are identified in the opposition, that they intend to essentially kind of trickle out, I didn't see him drink too much. I saw him drink moderately. Try to give impressions of habitual behavior in order to establish habitual behavior, but without anybody who is actually there present at all times. It'd be different if we were talking about Mr. Herbst himself. He could testify as to what his habits are when people aren't around. It would be different perhaps if it was his spouse. She or he would be there when he's, on the daily basis to establish whether he's drinking real water habitually or drinking alcohol not habitually. With that said, I think one of our key points is really about the application of NRS 48059. The plaintiffs are trying to get this evidence in about his habitual behavior in order to establish his habitual behaviors. And that is not what is intended. This goes back to essentially law school evidence class. You're trying to establish somebody wears a seatbelt on a particular occasion through what their habit is. Here, we're essentially, plaintiffs are essentially trying to establish what Mr. Herbst's behaviors are habitually to establish that he is either a habitual drinker of real water or a non-habitual drinker of alcohol. And so while it might be argued that this is overbroad, really what this is trying to do is to prevent 7 witnesses, perhaps more, come in and testify. I saw him once with a bottle, so therefore he's a habitual drinker of real water, or I was with him on vacations and that makes him not a habitual drinker of alcohol. Nobody has provided testimony that's through depositions that they've seen him every day. He's always got a bottle of real water in his hands. That wasn't established in the depositions. And that's what this is seeking to try to keep out is speculation, speculative testimony through a mass of witnesses, all trying, where plaintiffs are trying to get the same things out of them, and who have answered on the record. No, they don't know on the record. They don't know on a regular basis that he was actually drinking it through firsthand knowledge. Now, some of them have, he told me he drank it. These are hearsay statements. And the exceptions to hearsay, even though Mr. Herbst isn't with us, don't apply here because they're trying to shoehorn this in through that habitual behavior statute. Does the court have any questions?
No questions. Thank you.
I'm not sure if you're changing off your inclination at all, if you have any questions or want me to address anything specific.
So if you're asking me if I'm changing my mind on this one, the answer is no. So if you want to save more time for other things, that's fine.
I'll save time. Yes, Your Honor. Thank you.
Thank you. So the court denies the Nevada Beverages motion limiting number 17. Reasons stated in the opposition, including but not limited to, whether you call it corroborating evidence or, circumstantial evidence, there's ability to consider that. The issues raised here really go to weight. And, of course, subject to impeachment and the relief is overly broad. One is fairly similar, but welcome argument.
Oh,
Our understanding was defendants wanted to, but we're trying to clarify.
Okay.
Trying to save the court some time, if we could, John. Okay, good enough. Your Honor, I think we got an agreement that they don't want to argue this one any longer.
Okay.
I do want to make a brief statement.
Okay. So they do. Okay.
Well, I wrote down argue here, but
Okay.
maybe I was wrong when I wrote that.
No, go ahead. I mean, if you want to argue, that's fine.
We put that time on the plan side.
No.
I mean, that was like 20 seconds. So let's hear from defendants.
ETT1 joined the Nevada Beverage Motion Limiting number 20 to exclude speculative testimony that Milo Herbst had low wine consumption outside the presence of the witnesses. I just want to point out that Milo's wine cellar, Milo's email handle, Milo Wino, Milo's medical records, all belie any kind of impressions, beliefs, and testimony of his family and friends that he wasn't much of a drinker. And all this motion seeks to do, and we join in this motion, is to prevent testimony that speculates about his drinking outside of the presence of his family and friends. And which is simply, and that he did outside the presence of his family and friends is simply corroborated and circumstantially shown by the businesses, the two bars he ran, his what will later become known as a men's club above that facility.
That might be the first time I've heard that one.
Yeah,
so
that's
far,
the first
but-
time we've all.
But, okay.
So I believe that's true. It's probably the first time that the courts heard it, I know. There was testimony by Mr. Tim Herbst that there was a bit of a unofficial poker gathering club up above the Spring Valley Market facility.
Okay.
It's been referred to as an apartment as well. Anyway, what the point of this motion and the point of our joinder is that folks that don't know what he was doing outside of their presence shouldn't be allowed to give testimony that they knew they don't know, and they admitted they didn't know what he was doing outside of their presence. So fair enough. They're good character witnesses. They're good people. He's a good people, but nobody should be allowed to testify what he was doing outside of their presence, especially in view of all the records, his own businesses and such. So that's all. I just want to put that in the record, Your Honor, and I'll reserve if there's a need to come back more. Thank you.
Thank you.
Your Honor, do you need further argument on this one?
As much as I would love to say yes, I do not. Thank you. When I simply write deny, to me, it's pretty clear. So the court denies this motion in limine number 20. These are issues subject to impeachment, cross-examination. It's overly broad and the relief sought other reasons in the opposition. Sounds like we may get more details on what the apartment or men's club or whatever it was. But, okay. All right, next.
Thank you, Your Honor.
Everybody needs help. The next three, there are no arguments, Your Honor. That would be Nevada beverages 18, 19, and 23.
Everybody,
I believe there's an argument in 24, but I'm not 100% sure on that one.
I don't believe there is, unless Terrible Herbst had an issue, but I agree with counsel on 18, 19, and 23. There's no argument. For number 24, Real Water will stand by the court's inclination to grant in part and deny in part, so long as there are redactions of amounts.
And I believe that's where we are, Your Honor.
I agree, Your Honor. Thank you.
okay, so all four then. So the court denies the Nevada beverages motion limine 18 for reasons detailed in the opposition. Court grants Nevada beverages motion limine 19 is unopposed. Court denies 23. Let's see. So 23, I mean, reasons in the opposition include but not limited to the evidence is relevant, goes to, the lack of a written recall policy and or compliance with an unwritten policy, also relevant to plaintiff's claims and damages. And then 24, grand part denied in part. Grand part to exclude amounts of prior verdicts, judgments, settlements. Exclude those things mentioned, newspapers and articles, and to require that the article and or headline that's in the photograph or photographs be redacted as appropriate. Okay. Next,
Next one, there is argument, Your Honor.
okay, 20, is it 25? Is that?
It is 25, Your Honor. It's my understanding that the court was inclined to deny. I believe that argument was asked for in terms of clarification.
Oh, sure. Yeah,
Yeah, Your Honor, I think we were actually inclined to let this go with the court's inclination, but since we have to argue, I think I just need to open this something procedurally.
sure.
As far as the Nevada beverage motion goes, I think most of it's moot because Nevada beverage is settled out. So to the extent that there's any argument about her qualifications on beverage distribution and all that, unless I'm wrong on that, but no, I hate to speak out of turn, Your Honor, but I skimmed through it and I think we can avoid a lot of argument on a lot of that right there. That becomes interesting because then if you look at the joinder, and that is a substantive joinders that the court was relying upon in reaching its inclination. Court reference page 3 of the joinder with that table. And for clarity, I believe it's the court's inclination to deny the motion. And the court said, allow Catherine Donnelly to respond with the rebuttal that's positioned there. So effectively let trial go and let the experts battle it out. Right?
Essentially, yes.
Okay. The opposition filed by the plaintiffs, Your Honor, doesn't address the joinder at all. Doesn't address any of the substantive arguments, doesn't address any of the law. I think it's procedurally improper to have any argument opposition to the motion at this point going forward because of the lack of written opposition. But to the extent the court's willing to humor it, we would support the court's inclination along with the rebuttal of Scott Donnelly on page 4. And we are fine denying the motion with if it's going to be about all the experts.
Thank you.
Thank you.
Yeah, I'm assuming no one from Terribles is.
What number are you?
25
7.
or 25.
25.
I would just ask counsel, say the number and I'll be able to more accurately answer.
25.
Thank you. No argument, Your Honor.
Okay.
Your Honor, the court's inclination was to deny. Unless something has been said that changes the court's inclination, I'll sit down.
Well, if you want, you're welcome to address, and allow essentially is summarize succinctly the battle of the experts on that table there in page 3 of the joinder. I think Connolly, I think, are the two there, but if you want to address that, that's fine. If you're okay, that's fine too.
I'm fine with it, Your Honor. The only thing I thought I would address was really and I believe that there's no question about her qualifications, but it was raised originally in the motion, Your Honor. And I wanted to point out that certainly Dr. Hutt, including the Wren case, is.
Oh yeah, she's totally qualified.
Totally qualified. Thank you, Your Honor. The other point they raised was whether or not her qualifications experience delve not only into food, but also into bottled or beverages, bottled drinks or beverages. And she works at Coors in addition. In the terms of her experience, Your Honor, she also founded the HAP. HACCP.
No, I remember that.
remember that?
Extensive testimony.
Extensive testimony in HACCP, Your Honor. Additionally, she took it from NASA to the food industry. Beyond that, she also was involved in actually using 21 CFR 117, Your Honor. She was the one who actually began applying it for the Department of Agriculture and for the federal government, Your Honor. So what I thought was the issue beyond her qualifications and experience was comments made in terms of what she would be providing opinions on beyond hydrazine. And if you recall, and this is something the court said, I think last Monday, this is not just about the creation of hydrazine.
No, I mean, maybe you and I are not worships of the night, maybe, but I'm inclined to deny it subject to, hey, have the battle of the experts.
So, and the reason I say this, Your Honor, in terms of the battle of the experts, if Catherine Donnelly is talking about HACCP-related issues, that's one thing. If Catherine Donnelly or her husband, Scott Donnelly, were to delve into Superfund or delve into, that's where I had a problem.
Yeah, that's so the
Okay.
table, if you look at, and I'm focused, hopefully understandably on the detailed table, which was helpful, I thought. It's not going over the super fund or whatever that other, there were two, I think, but this table, hey, there's permits, there's registration, regulation. Dr. Hutt says, oh, it's, essentially they did everything wrong. Dr. Donnelly says, no, it's okay. Yeah. So this does not get into the super fund or the other issue that was related to that one.
Okay, and Your Honor, if that's the case, then I think we're fine with the court's inclination.
So
I didn't want it to bleed into that. That's still, sitting out there for the court.
welcome any rebuttal or clarification from the other side if they want.
Sure, Your Honor. Your Honor said it better than I could. I think your court's inclination is viable, and that's what we recommend the court go with.
Okay.
Yeah.
So it's denied with the clarification that has set forth in detail there on page 3 of the joiner in that table. I mean, you summed it up better, battle of the experts on those particular issues, and not getting into any other issues that may or may not be outstanding in other motions, but detail in the table. We'll see how it goes at trial.
Thank you.
Okay, thank you. Next. 26.
Your Honor, I think the parties are okay with number 26 and number 27, the next two.
Okay.
And then, is that correct?
That is
That
correct.
is correct.
Okay.
26 and 27?
Yes.
That
You
is
have to
correct.
ask your
Thank you,
co-defense counsel too.
That's correct, right?
Yes.
Okay, so beverage 26 denied without prejudice for reasons detailed in opposition, including but not limited to going to wait subject to cross-examination impeachment. 27 denied without prejudice for all those same types of reasons. Okay.
And Your Honor, the next one up, I think, is number 28, regarding real water admissions and stipulation regarding liability and medical causation. And I think the court was looking for a distinction, so maybe I can help with that.
Yeah, bear with me. Let me turn to
And I promised to be brief.
that. We'll see if you do better than some of the other folks at the.
I promise you I will, Your Honor.
Okay,
Just let me know when you're ready.
I am. Thank you.
So essentially, I think there's a couple of distinctions. Number one, Milo Herbst has a chronic liver injury as opposed to the acute injuries for the other individuals. But going back to your decision on plaintiff's motion in limine number 5, I believe you've already said that causation regarding Milo Herbst is fair game as opposed to others. So looking back on my notes from that decision, I think that is where we are. So I think we have to live with any prior decisions you have on issue preclusion, but you specifically carved out causation as to Milo Herbst, which is the purpose of this motion. And if that's the clarification you needed, then that is all I have to say.
Okay,
And I did my job.
You
And it was
did.
fast.
Your Honor, Jim Cavanaugh for TT1 Terrible Herbst, and we joined in Nevada Beverages motion limiting number 28 to preclude prior case stipulations as to liability and causation, but to liability, which did not pertain to Milo Herbst in this case, and therefore they should not be relevant, or they would not be relevant and should not be admissible. As courts aware, all the prior cases but one, and it did not include retail parties, did not include Terrible Herbst or UTT1 or its convenience store Terrible Herbst, other than the Hunwardson matter, and the stipulations to liability that had been found to exist with regard to the real water defendants became applicable effectively to ETT1 in that Hunwardson case simply because of a sanctions decision the court had made in Hunwardson. There's a number of reasons it wouldn't apply to this case that counsel just pointed out for real water, the chronic nature of the injury to Mr. Herbst versus the acute plaintiff injuries and the other matters. And understand that half of this motion eliminate really are moot by the court's prior rulings. The causation is still fully in contest or in play, as counsel said. But even the stipulations liability would not apply either, and should not be, the other defendant should not be saddled with any stipulation that it wasn't a part of. And just to backtrack to the Hunwardson matter, it was settled. It was settled in its entirety, irrespective of the sanctions that were being imposed on it. And it was settled completely. And going forward in other cases, stipulations by counsel that occurred 5 trials ago or 3 trials ago or any time, this liability, those were never litigated with regard to my client. So it's the stipulations liability that were entered into are not relevant. They weren't litigated, and it's unfairly prejudicial to even allow the stipulations as liability, which are substantially outweighed by the prejudice that would be unfairly leveled at my client by a jury if they were to think that we had stipulated or were subject to stipulated liability. I'll reserve unless the court has other questions now.
No questions now. Thank you.
Your Honor, the comments of counsel are interesting. I don't think they're accurate, but they're interesting. Judge Kitchener found Terrible's to be at fault in terms of granting a motion for summary judgment, which you've seen. In the Brown case, motion for summary judgment was entered against Real Water. Your Honor, it's not just stipulations. There's been findings by the court.
I think I relied primarily on Judge Kitchener's order and my order granting partial summary judgment.
You did.
Okay.
And so when I hear the comments of counsel, it's in complete contrast to what's been done in this case, not only before Your Honor, but in Judge Kitchener's court when Terribles went to trial for the first 2 weeks or so. So Your Honor, it's just historically incorrect what Mr. Cavanaugh has just said. The other point, Your Honor, and I saw this in the motion. In the Nevada Beverage Motion, page 6 of 10, it says, unlike the plaintiffs in prior cases, Mr. Herbst, I was about to spell it, but I said, no, I won't tease him like that. Had significant history of alcohol abuse and underwent chemotherapy, both of which could have been contributed to his liver failure. Your Honor, this case is not different than, for example, the Quanti Henry case, where they said he was drinking 1/5 of alcohol daily in addition to beer. It's not different than several of the other cases where Real Water and other distributors and retailers have ultimately settled, but during motion and limine practice, where Judge Kishner has struck their experts for coming up with some novel ideas as to causation when they failed to consider substantial factor under the restatement second of torts. Your Honor, this case is no different than Shaparov in terms of Milo Herbst. Shaparov, Nikolai Shaparov, at one point, has been argued he abused alcohol. Your Honor, this case is not different than any other cases. From the case, the first case Gallagher until now, we've had, sometimes double-digit plaintiffs with a variety of habits in terms of alcohol. But they've never been able to determine, and certainly they've never agreed in any of the prior cases, that alcohol, not hydrazine, was the cause of their acute liver failures or liver injuries. But that's what we have here. And so they're trying to keep out what has been determined by this court and other courts, or admissions that they've made. And what they try to do is they try to circumvent the Krause case, Your Honor, the Guinness case. They're trying to avoid determinations already made and positions they've taken in other cases involving this same product. Your Honor, your prior decisions have, in my opinion, I wrote down in this moot, given your prior opinions. But I wanted to make sure we put this on the record because when I saw the arguments in Nevada Beverage, they're somewhat dissimilar to some of the arguments you heard today. But that's how the motion started out, and that's how we opposed the motion. Your Honor, there's no reason why this couldn't come in. All the case law that we've cited is actually on point. And the other thing that was not mentioned, Your Honor, which is again under the restatement second of torts, everyone in the chain, from the manufacturer to the distributors to the retailers, they're bound. They're strictly liable in Nevada. And so when Terrible tries to divorce itself from a manufacturer who now we know, based upon this case and the previous cases, created a contaminated product and sold an adulterated product, which wasn't changed when it went to the distributor and wasn't changed when it went to the retailer, they're stuck with that. And it's because Nevada and our Supreme Court has determined that consumers should be protected at all costs. And I'm kind of paraphrasing the language from the case, Your Honor, but certainly that's what it says and that's what it stands for. And so we should be able to get in the prior claims, which the court has already said in terms of prior complaints. And we should be able to get in the fact that in these other cases with these other plaintiffs or claimants, we'll call them, the court has made these decisions and or stipulations were entered into. Even their own experts, our experts and their experts. And we put that, I'm sure you saw it in the opposition. We pointed to their experts that said, given what Real Water is already stipulated to, or given the findings of the court, it's inconsistent because we didn't know that they took responsibility for 2016, 2018, 2019, 2020. So, Your Honor, there's no way, because we've already cross-examined them during deposition with that same information.
So a lot of your argument sounds like affirmative relief versus
Denial.
yeah.
And I'm supporting the denial, Your Honor.
Okay.
If there's anything else you need from me, this is more, you're right. I'm happy with the denial. I'll just give you some ammunition for the record, John.
Thank you.
Thank you.
Any rebuttals?
Yes, Your Honor, briefly.
Oh, I apologize. I think I had a question for you, Mr. Parker.
Well, I need my binder.
Depends on how good your memory is.
Certainly, Your Honor.
So one of the representations was that on plaintiff's motion limiting number 5, I ruled that causation vis-a-vis Mr. Herbst is fair game or at issue. Would you agree that's what I already did?
That's my recollection, Your Honor. My take from that was that in terms of Milo Herbst, they have to prove product. We have to prove that he drank or consumed water from Terribles. Other than that, you've already found the other parts of the liability.
Well, and
issue.
that, when he drank water and the real water and two from, for
Terribles.
example, terribles, and then that caused. Was it, let me be a little more specific if I can, because this is an issue that you all have already, was a substantial factor in causing harm to him.
Absolutely.
Okay,
Yeah, we're on the same page there, Your Honor.
okay, thank you very much.
You're welcome, Your Honor.
Briefly, and not to retread causation issue at all, on the liability aspect of this, Your Honor, just if Your Honor looks at, I thought I had printed the entire opposition, but I believe Exhibit A or Exhibit 1 to the opposition is in fact Judge Kishner's, is a transcript of the matter discussing.
One is Williams, let's see, two.
Judge Kishner on page 7 or 8 of the next exhibit. I apologize.
Two is a stipend order.
There's a transcript there. Judge Kishner is explaining in that transcript the basis for her sanction and the stipulations to liability applying, which I believe is maybe helpful to solidify further to the court why it chose to follow Judge Kishner in some of the rulings. It may be that, I don't have it with me. The council's got their own op.
Well, I mean,
If there's a
are you
transcript.
okay if I deny the motion but grant it as to Mr. Herbst, given that causation, the consumption issues, the causation issues are still in play?
I am, Your Honor.
Okay. Any more rebuttals?
No, I just wanted to clarify that.
Oh, I know you, for me, I'm asking you.
No, thank you, Your Honor.
Thank you, Your Honor. Appreciate it.
Thank you. So,
Good caveat, thank you, Your Honor.
thank you. So denied, court denies number 28, except for grants as to Mr. Herbst, because, purchase from Terrible's, consumption of whether it was a substantial factor causation, those are still up for consideration by the jury vis-a-vis Terribles.
Thank you, Your Honor.
And real water, because we don't know if you actually drink real water, that'll be for them.
Thank you, Your Honor.
Thank you.
Have one.
Sure,
Clarification
sure.
point. I apologize.
That's okay.
I'm trying to figure this out logistically. In court, if we put that in front of an expert who is our expert, causation expert for all, I say 9 plaintiffs, it'll come in. How would it not particularly impact Herbst? For example, we call Dr. Khan or Dr. Sato on the defense side. We say, Dr. Sato, you've determined that real water caused liver injuries for 9 of these people, and you've seen the stipulations and the determinations that real water accepted responsibility for all these years. How is that going to impact the jury in terms of Milo? I just throw that out there. I guess we can deal with it when we get to it, but I just wanted to make sure the court's aware. You're not including that.
Don't talk yourself out of what I've already done.
Thank you, Your Honor.
Okay. 30? Time for a break. How many more?
30, Your Honor.
Okay, so
That's correct, Your Honor.
30 denied, this is Nevada beverage motion limiting number 30 denied for all the reasons in the opposition. Be mindful of the time we'll have in the next hour or so.
Thank you, Your Honor.
The reason that they want to exclude it is because they said that there's not sufficient studies or otherwise Again, that's incorrect because the FDA still has it. They also say, well, the FDA is removing black box warnings on other things. So that's why it's prejudicial. But again, that doesn't go to the heart of the issue. I think they cite to the FDA removing black box warnings on hormone replacement. But again, that's not the same thing as isoniazid. To date and currently, the black box warning for isoniazid relating to alcohol is current and is still active. And so that's why their argument on that point was kind of confusing. And if you're looking at their motion, I can tell you that bit. That was their motion on page 6, lines 23. It says, FDA has initiated removal of other black box warnings, see menopausal hormone replacement therapy. And so the whole underlying thing is they said after 30 trials of hormone replacement, the FDA began the process of removing. But again, that's comparing apples to oranges. And so it's really confusing why they're trying to cite to that, because again, isoniazid, all the studies show that when you drink alcohol with isoniazid, there's exponential, the correlation, it's a synergistic, and you probably heard the word synergistic several times already, causation here. So the basis for their request to exclude this is based on drugs that are inapplicable here. And so that's why their motion really doesn't have any ground to stand. And it's not prejudicial or otherwise, like I said, the experts rely on this. It's relevant to the case because the FDA is acknowledging that hydrazine and alcohol together are synergistic. Experts rely on it on both sides. So it's relevant, it's not probative, it's relevant, probative, and not unfairly prejudicial. Sorry, got ahead of myself and my words sank in Parker. And so that's why we think that they have not met their burden to deny this evidence, because again, menopause hormonal replacement is not a basis to preclude isoniazid. Thanks.
Thank you.
Your Honor, I think Mr. Freeman was going to, Terrible Herbst may start the argument here. Mr. Freeman was going to argue this, but he said the audio is not on.
We can,
It got turned on now, thank you.
okay. Go ahead.
I'm gonna defer and rely on the papers, right?
Okay.
You're Eric Freeman on behalf of Real Water. I just wanted to add, the FDA opinions is not causation. Black box warning or studies linked to the warning showing over 98.5% is non-injury. That's not sufficient to prove more likely than not causation. These warnings are
so
just.
let me ask you, because this is one where the relief's probably a little bit in question, especially given what you just said. So the motion exclude reference to the black box warnings. And you just mentioned the studies that led to the black box warnings. Are you seeking to exclude those as well?
Well, basically the entire warning, FDA's comments, studies, the warning, these are just precautionary measures. It's not proof of causation. It's not expert testimony. It creates false scientific certainty on these things. It leads, it would lead a jury just to presuppose that because of this black box warning, Mr. Herbst's injuries were caused by real water that contained hydrazine. And if they presuppose this, that's presupposing causation before any expert testimony or evidence.
Thank you. Any other rebuttal? Or did you defer to? Okay. So as you heard, I was inclined to grant it, but plaintiffs, because plaintiffs were arguing something that I didn't think the motion actually sought. Now it's been clarified with argument and the answer to my question that actually is what plaintiffs were arguing. Which, you know, there's not a basis to grant the blanket exclusion sought as clarified in argument. For the reasons plaintiffs are articulated. So gonna change my mind on this one, deny it without prejudice. The relief sought is overly broad. It lacks, you know, the issues that the study's not enough and that type of, those are weight type of issues. Yeah, so denied without prejudice. Okay.
There is no argument on 34 and 36 between the next two.
Okay. Everybody confirm that?
Would get clarification on 36, Your Honor, maybe hear your ruling.
Okay, so everybody clarify 34.
34 is denied. Yes, that's fine.
Okay, so the bad beverages 30, motion limiting 34 is denied. The bad beverages 36. Oh, by the way, defendants have taken a lot more time than plaintiffs have. So you've got like probably about 15 minutes or so left now. So just a reminder or a warning.
I think
Okay.
Oh, he's gonna argue.
He's calling audible at this point. I thought we had no argument, but that's fine. We'll just wait.
Okay.
I just wanted clarification on 36, Your Honor. That's understood. It goes to the weight and the denial is without prejudice.
The denial certainly without prejudice, yes. Did you want more clarification?
Not at this time, Your Honor. That's sufficient.
Okay. Next. 37.
Your Honor, on this one, I just had a quick clarification.
Well, this isn't your motion yet, so, or did you all agree you can ask first?
We would defer, your.
Oh, okay,
It was
okay,
clarification
sure.
that plaintiffs needed.
Sure. Okay, go ahead. Go ahead.
Yes, Your Honor. So the inclination was to grant in part and exclude as to specific causation. And
As to hers.
as to hers, yes, Your Honor. And I put in the opposition that Dr. Cosnet does not give any specific causation opinions as to Mr. Herbst.
Okay.
And I think that is correct. He didn't look at Mr. Herbst's medical records. He doesn't say alcohol, how much he drank, how much real water, substantial factor. He doesn't opine on all those. He's a general causation expert. However, with respect to a rebuttal to Dr. Stelpflug, who's the defense expert, he does give an opinion that mentions Mr. Herbst by name, where he says, Dr. Stelpflug gives a specific causation and he distinguishes hydrazine from alcohol. And my general causation opinion is that they combine together, they can both be substantial factors, and he doesn't consider that. And so I just want to make sure that in denying and saying no specific causation opinion, we don't have a dispute later on if this testimony somehow still becomes relevant and we call Dr. Cosnet that there's not an accusation of an intentional violation of the motion, Your Honor.
Thank you.
Thank you.
Yeah, any,
And Your Honor, with that, certainly it's basically specific causation. If he did consume real water and if there was hydrazine in it, it is highly unlikely the amount of hydrazine possibly consumed could cause acute injury. Then I think Dr. Cosnick goes on to talk about, essentially it's if testimony. If he drinks the real water, if it had hydrazine, then he has a specific opinion. And I think we can live with that unless counsel for Terribles disagrees with me.
I'll go with the majority here. I feel like it's, 1 minute he's got no opinion on causation and now he's rebutting another expert who does have an opinion on causation. His initial report is different from his rebuttal report. But I think the court was inclined to deny the motion. It goes to wait without prejudice unless the court was going to clarify it differently.
I think the court was going to grant specific
as
causation.
to first, so the court sticks with the initial inclination with the clarification, because I actually do remember that particular issue that Mr. Pepperman mentioned. And I think that would not, as limited there, would not violate the order, to be clear, but it's granted to exclude specific causation regarding Mr. Herbst. Denied as to any remainder, and with the clarification on that, because yeah, he's a general causation guy, and when addressing, that particular issue in the rebuttal, I don't see a problem with that. But again, if make objections at the time of trial, regardless of my ruling. So, okay. Next.
No argument on 38.
Okay, 38.
That is correct, Your Honor.
Okay, 30, without beverage motion 38 denied for the reasons detailed in the opposition. And then 39. I think I wanted some reminders on this one, if I recall. But welcome whomever's going on behalf of the defendants.
Gina Mushmack for Real Water. So first of all, I'm not sure if the court has ruled on plaintiff's motion to eliminate number 1 yet. So this may dovetail into the court's decision in that regard. And I think you were maybe that it's under advisement until tomorrow, but regardless.
Okay. I have not ruled on number 1 yet.
Yes.
Okay.
But regardless, reference to the exclusion of Dr. Atchison's DABS opinions in another district court case. This has nothing to do with the claims and defenses in the present case. Judge Kishner said the DABS opinion was based upon speculation and not supported by factual foundation. However, whether that decision would have withstood an appellate challenge is unknown. As this court is aware, rebuttal testimony can contradict an opposing party's expert and furnish reasonable alternative causation. We've talked about Levitt v. Sims lots of times for Your Honor. Plaintiffs also want to use this exclusion as somehow authoritative as to Dr. Atchison's opinions. In this case, Dr. Atchison opined based upon Mr. Herbst's admitted 5+ decades of alcohol use and medical evidence from multiple providers confirming alcohol cirrhosis of the liver. And he said Milo Hurst suffered alcohol cirrhosis of the liver. This isn't speculative. Dr. Atchison did not consider real water as a plausible cause of Milo Hurst's liver damage because there's a lack of evidence as to whether he drank it. Milo Hurst's onset of liver damage does not track with the other acute injuries sustained by other plaintiffs in this case, the 5-gallon jugs, 2020 outbreak, etc. This is not about bias or credibility. Atchison did not rely upon his prior opinion for his opinions in this case, and we believe this would cause confusion because Hunwartson in that case suffered acute injuries versus Milo Hurst, who had a chronic liver injury related to alcohol use.
But generally speaking, again, you're arguing, I think, an exception, but generally speaking, it's fair game to cross and impeach an expert, whether they've ever been excluded, right?
That's true.
Okay. But you're saying doesn't apply here, because of the differences, in Mr. Hurst versus, other plaintiffs. Is that fair?
Correct. And it's a district court opinion, not an
Oh, yeah,
appellate
yeah.
court or Supreme Court opinion where it was ultimately confirmed that he was speculating, etc. Okay.
Thank you very much.
Thank you.
Any joiner?
No, you're right. Reserve. Thank you.
Okay.
Your Honor, I wanted to address your inclination. What I wrote down on this is Your Honor started to say, if Atchison's opinions are in, and I'm not sure where I'm at on those, but then the rest of your note, did it make sense?
Yes.
And I do think I know where the court was going, because that was the nature of the opposition is, motion limine number 1 seeks to exclude Dr. Atchison. That is pending before Your Honor. If that motion is granted and Atchison is excluded, this motion is moot. But if he's allowed to testify, then I think Your Honor said it more succinctly than I ever could, is it's fair game to cross-examine a witness on prior exclusions, and that's par for the course when the prior expert's been restricted or excluded. And Your Honor, I think if you look at the opposition on page 8, we go through, cite multiple cases on this. People v. Hoyos, an expert's testimony in prior cases involving similar issues is a legitimate subject of cross-examination when it is relevant to the bias of the witness. The expediter's case, allowing cross-examination on potential inconsistencies between views expert intends to express in pending litigation with the testimony and opinions he's given in theories and methodologies he's used in prior cases. And then the Phillips case, where plaintiff's entitled to inquire as to the expert's prior expressions of opinions, in that case about forklifts and other injuries sustained by the operators, noting that it goes to bias, which is, of course, one of the quintessential bases for impeachment of a witness. And that is exactly what we have here. I mean, similar issues, it's real water. I respectfully disagree with counsel's characterization of Mr. Hunwartson's injuries. He had cirrhosis. He had to have a liver transplant because of his cirrhotic liver injury. The only difference in terms of the injury is he actually received the liver transplant and survived. Dr. Atchison's methodology and opinions are all the same. In that case, he said, oh, it couldn't have been real water. I don't consider real water a possibility. It had to have been something else. And there it was the dabs. Here it's alcohol, but it's the same issue regarding his methodology, where it's anything but real water. It's prior relationships with real water. So he can't be insulated from being asked about his prior opinions, including that they were stricken. It's cross-examination. We don't seek to admit extraneous evidence. And Your Honor, I think for the reason you succinctly stated, it's fair game and the motion should be denied.
Thank you very much. Any rebuttals?
Your Honor, just briefly, dabs has nothing to do with this case. Dabs is apparently a marijuana derivative or whatever the chemical name is for marijuana. And that's not an issue here. And of course, you can cross-examine a expert on his qualifications, and it's fair game to examine him on certain prior opinions, but I believe the intent of the Dabs cross-examination would be to discredit a witness who has looked at the Hearst matter and came up with opinions he was qualified to give, can assist the jury, and he's within the scope of his expertise. And that's all I would say.
Thank you. Any further rebuttal?
No, Your Honor.
So to be clear, depending on how number one, I actually rule on this would be moot if I were to rule in plaintiff's favor, but I haven't done that yet, so it's a live issue in front of me right now. And the court's going to deny Nevada Beverages motion limiting number 39. And I don't say the joiners, but to be clear, these all affect the joiners as well. But so the, you know, bias, qualifications, impeachment, those are all fair game on cross-examination, including this issue. Now that's not to say it's, you know, open the door wide to everything, but a limited type of cross-examination is appropriate. As to a fairly unique argument, the argument that there was no appeal or appellate decision, you know, I don't know if I'd heard that one before in this context. So I appreciate that. I will say, however, I disagree with it.
Thanks.
No, I mean, it's good lawyering. It just, that's not the rule, and really couldn't be the rule. That, you know, the argument's essentially, well, there was no appellate decision, therefore an exception to the general rule would apply here. And that just isn't even the exception to the rule. So yeah, okay.
There's no argument on number 40.
Oh, okay. Does everybody agree with that?
Yes, Your Honor.
You can write up.
Okay, defense motion limiting number 40 is denied for reasons detailed in the opposition. Then do we get to terribles number one? Is that
Yes, Your Honor, that's.
okay? Okay. Any argument on terribles number one?
Yes.
Okay.
Nathan Arrington appearing on behalf of ETT one as terribles. The complaint alleges a strict liability claim. We've gone over that quite a bit. As a part of that, terribles could be liable as a homeowner. Okay, however, there is no allegation of a joint venture. There's no allegation of a partnership agreement because there is none. So our position is that while they can hold us liable for strict liability, they cannot allege and argue that there's a joint venture or that there is a partnership. And on that basis, I'm done. Do you have any other questions?
No questions. Thank you.
Thank you, Your Honor.
Your Honor, before I take the podium, has anything been said that changes your?
I'm not sure, but go ahead and take a couple minutes, maybe.
Your Honor, the title of this motion was to exclude argument or reference to Terrible Herbst as the marketing arm or having any business relationship with Real Water. we submitted, in our opposition, Your Honor, several documents, emails, talking about the relationship in terms of marketing, free water given by Terrible Herbst of Real Water, thousands of bottles. The way strict product liability works in the state of Nevada under the restatement second of torts is if you're in the chain, you're in the chain. I really am confused somewhat by Terrible's motion. There was relationships between the two companies in terms of the bottles being in their locations, the number of stores that were selling. They actually had the Real Water advertisements playing on the pumps. To say that there was no relationship defies all the evidence, Your Honor. And so for that reason, I don't think this motion has much merit to it.
Thank you very much. Any rebuttal?
Yes, Your Honor. Yes, so we're clear, we're not disputing that there is potential liability under the strict liability claim, okay? But there is no allegation in the complaint for a partnership or a joint venture. Those are not agreements that exist. So, yes, there is potential liability with regard to the fact that Terrible is a retailer. But there is no partnership liability and there is no joint venture liability because A, that wasn't pled, and B, there is no such contract.
Thank you. So this is one where the arguments aren't necessarily what's in the briefs. So court is going to stick with its initial inclination, deny Terrible's motion eliminating number 1. There is evidence, there is relevance to this relationship. So denied for those reasons in the opposition. Number 2.
Just rather briefly, can I just clarify the court's inclination prior to progressing the court?
You could ask. I don't know if I'll answer you, but sure.
Fair enough. All right, well, I can just come up again and
Yeah, whatever works, it's fine.
unless you're about to comment. Oh,
No, all my note says is deny, so.
okay. ETT1 LLC DBA Terrible Herbst. Motion eliminating number 2. Ask the court to exclude argument, reference, or evidence, including expert testimony that Milo Herbst liver injuries or death were caused by the consumption of real water sold by Terrible Herbst, or that Terrible Herbst sold hydrazine adulterated real water to Mr. Herbst. Two sides of the same coin. As the court has heard before, I believe in relation to other motions and comments, attached to the motions and the reply brief are exhibits, numerous exhibits, including deposition transcripts and responses by plaintiffs to the question as to what evidence do you have, what are plaintiffs, who are plaintiffs' witnesses, and the documents plaintiffs intend to produce to prove its claim that anyone observed Milo Herbst purchased real water from Terrible Herbst or consumed real water purchased from Terrible Herbst. The plaintiffs identified, and I'm going to make this brief, but I want to put them in the record, the following witnesses, including the plaintiffs: Tevis Herbst, Sarah Calovi, and John Calovi, Charmaine Ferrari, Russell Riggs, Ron Murphy, Kathleen Hurst, H-U-R-S-T, Riley Miller, Kyle Widner,
Gene Widner. And they referred to in their final discovery responses served a day after close of discovery on November 11th. We deposed each one of those witnesses, and not a one said they observed Milo Herbst purchase real water from Terrible Herbst. Not a one of them said that they could testify he consumed real water purchased from Terrible Herbst. I understand the court is inclined to consider other testimony that may be viewed as circumstantial evidence, and that for that reason, the court could not at this time grant the requested motion to eliminate relief. Does the court have any questions? If not, I'll reserve.
No questions.
Thank you, Your Honor.
Thank you. While he's looking at that, the timing defense side, we're at about 8-9 minutes. Boom. You okay with my initial inclination?
I'm good with your initial,
Okay.
inclination, Your Honor. I was getting ready just in case you wanted to hear something.
Yeah, you know, this one, I think is fairly straightforward.
Thank you.
Going to deny it without prejudice. As we talked about in other motions, there's circumstantial evidence, and I guess I would add on this one, it's characterized as a motion in limine. Substantively, it's much more akin to a motion for summary judgment. That standard's also not met, but there you go. Oh, this is the last one.
Thank you, Your Honor.
I think we're on the last one, Your Honor.
Okay. Which number was it again? So, okay.
My understanding is the court was inclined to grant as to the specifics and lines 8 through 15 on page 5 of the motion.
Correct.
So if that is the court's inclination, we think it's an excellent inclination, we would agree. Reserve.
Sure, thank you. Any argument in opposition?
Your Honor, it's not a. Yeah, some comment, I just. Yeah, I just.
That's an attorney way of saying argument.
It is. I was trying to find another way of saying it. I couldn't come up with anything creative on the spot, Your Honor. I'm not concerned so much about item number 1, Your Honor. On page 5, line 10. And I certainly do not intend to argue that Real Water engaged in improper litigation tactics. So that's not the point. So if that, with that clarification or concession, Your Honor, what we've done in the past, and you saw this come in front of you, in terms of the Wren case, and we've done it in front of Judge, I think each of the cases, all 5 of them, as a matter of fact, to display the length of time and the efforts undertaken to get the case to the jury. So it's not to show that any defendant was improper in how they defended the case, but the work and the effort that went behind bringing the case to them, which is certainly in our opinion, and has been allowed by every judge, Judge Kishner, Judge Williams, and yourself, to demonstrate the efforts that it took to bring the case in front of the jury. And so as long as we're doing it for that reason, as opposed to doing it to criticize or critique the efforts of the defendant, I think we're fine, because we took some of the depositions. They weren't all taken by us, and they weren't all taken by the defendants. It was both parties took depositions, and both parties engaged in discovery. So I believe as long as we're not offering it for that reason, and we're not characterizing the defendant's actions as improper or wrongful, then I think we should be able to say what we've done to get the case and bring the case before the jury. So if that's fine, Your Honor, then we have no any other objections to this page and those, I think, Romanet 1, 2, and 3, because we're not suggesting bad acts.
Thank you. And then any rebuttal?
Just briefly, Your Honor, I want to make sure that I have a firm understanding
Sure,
of
sure.
what this is. So if you don't mind, I may talk to Counsel Parker. I know it's not normal, but
That's fine.
Counsel, so my understanding is that you are agreeing to preclude any reference to the length of the discovery period, the numbers of depositions or motions to suggest the real water defendants engage in improper litigation tactics or otherwise protracted litigation. So you want to be able to cite how much work went into working the case up, but not utilize or weaponize that information to infer anything untoward about real water engaging in the defense or any of the defense engaging in the defense of their claims.
That is correct. And just to make it clear, Romanet 1 says engage in proper litigation tactics. I won't make that allegation. Romanet number 2 says bad actors. I'm not going to make that allegation or assertion. And the other one is immoral conduct. I won't make that assertion as well.
Okay, so the only thing I want to make sure we're stipulated on here, just for clarity, well, and Your Honor, obviously subject to the order, but you know what we're doing here. Is the precluding the reference to real water defendants representatives not appearing at trial. We want to make sure that that specifically is excluded and for reasons that were demonstrated at the Bonner trial.
In the other trials, I said they didn't show up.
Correct.
And I couldn't say that all the time because in one of the trials, you put on the deposition testimony and you had them, that was actually in the Wren case.
No, we did that
And I
at
said
Bonner.
wasn't your firm. But I couldn't make that representation in that case. So if they don't show up, certainly I can say that they didn't show up, but that's their choice.
So, and therein, Your Honor, I think that's why I wanted to
Sure.
make a clarification. Counsel Parker, I appreciate the transparency. So, Your Honor, let me tell you what happened in Bonner. In Bonner, much like this case, we were unable to reference the bankruptcy. Now, as Your Honor is very well aware, bankruptcy comes with certain triggers and certain rules and, well, an entire code, really.
So let me cut you off. You're okay with them and you know, the work, the length of time to get the case in front of the jury. You're okay with that clarification, right?
Yeah, the data of we worked so hard to build this case up, fine.
Yeah.
But when it comes
what you're
to-
not okay with is plaintiffs wanting to say, hey, they didn't show up here at trial. That's still an issue.
Correct.
I'm gonna grant the motion on that. Given, because I'm cutting you off because I think it must have been in the briefs because I had your same concern about how it was used. I'm not saying, you know, in a lot of this stuff, things were fine because they weren't objected to or whatever. But you're raising in front of me, so that's also part of the granting of the specifics. So, you know, you can't, so plaintiffs can't argue in front of the jury, hey, they didn't show up and they're not interested. I forget the way it was used in that other case was I'm going to, at least me as my district judge, going to exclude that.
Okay. I appreciate that, Your Honor. Thank you.
Thank you, Your Honor.
Thank
So
you.
denied in part and granted in part?
Well, I would say granted
Pursuant to the
as
stipulation.
detailed in the stipulation and in page 5, 8 through 15, and as clarified by my comment and ruling on the non-appearance issue as well.
Thank you, Your Honor.
Thank you, Your Honor.
Is that all for today?
That's it.
Okay, good job. And, oh, hold on. Oh, not today. Yeah, so Catherine Donnelly, Atchison, those are still for tomorrow. Okay.
Your Honor, sounds great. If I may, did the court reach any conclusion on what specifically you were looking for additional argument on that, or are we just gonna answer questions on the fly?
Yeah,
me too, but you know.
Candidly, I think my answer is no, I did not reach any further clarification. The reason being is all the other
A
stuff.
little bit of stuff going on.
Yeah, if I did, I'd let you know, because that's a good question, but
Works for me. Thank you, Your Honor.
thank you.
Thank you.
See y'all tomorrow.